Hello, everyone, and welcome to the life and legacy of an immigrant. There is a really good reason why I wanted to start this channel, and I'm so very excited to embark on this journey. And I hope that it will be educational and hopefully inspirational to the people that do subscribe to it and listen to it. I'm Namrita Notani from the Law Office of Namrita S. Notani PLLC, and it is my utmost pleasure and honor to be here and to be able to talk to you all about estate planning. Why is estate planning so very important for us, for the first generation immigrants that are here? For one thing, we take for granted a lot that we were born with, raised with when we were back home. Families were different. The people around us were people we knew, and we could depend on them because they were families that were close by, close knit communities. Over here, a lot of times our siblings don't live close by. Most of the time, our parents are still overseas, and we are little units, little islands, and we raise our families in those little islands without the support that we were so used to when we were living back home. And a huge part of estate planning is not just about distributing your assets or figuring out where the tangibles go. A big part of it, especially from what I consider most important, is making sure that your values, your aspirations, your culture, a lot of those intangibles are also given down the descendants to your generations to come. And that is also part of your wealth. That is also part of your asset distribution, as you may call it. So estate planning has the family personal aspect of it. It also has the tangible asset protection aspect of it. And as an immigrant, both those aspects have some very special issues and things that we have some misconceptions about that we probably don't understand or know or have maybe not even been given a chance to explore. And that is what I want to hit upon, just a few little facts and snippets here, not the whole big detailed legalese that would confuse anybody, but just stuff that maybe you can go back and consider and think about. And if you ever have any questions, you can definitely approach an attorney or me, or of course, there's always Google. But just make sure that the information you're getting is accurate and is well thought of. It's something that is coming from a source that you can actually rely on. So let's talk about the main difference between a will and a trust, because that's one of the first questions that I get when somebody is sitting across me. They usually think that I tell them that they need a trust over a will because a trust is just more complicated. There's a lot more to go with it. A lot of times it's more expensive. Well, they've just heard certain things about a trust. So, here are some of the most common questions that are asked about a trust versus a will. So let me just tell you the answers really quick. The main difference between a will and a trust is that a will is a letter of distributions. It's basically saying that after I die, these are my assets, and the assets are not really given in detail in the will, but these assets are going to be distributed according to these rules. And I'm going to appoint an executor, that is the person who is going to collect those assets after I die and collect them into an estate and then basically distribute from them to my beneficiaries, to the people that I want those assets to go to. Those are my beneficiaries. And so that is what a will does. In essence, it basically allows you to tell the court that these are the people that are my children or my loved ones, my siblings, and these are my assets wherever they may be, and this is how I want these assets to go to these beneficiaries. The thing to remember here is that when you do have a will, the executor of that will must take that will and go to court, and then the judge must validate the will after the will is admitted in court. That's the probate process. And then the executor is appointed under oath. And then the executor has to, at that point, gather all the assets and try to put them in an estate and then give it or distribute it to the beneficiaries. Meanwhile, they also have to file an inventory to the court, to the judge, and say, hey, these were all the assets that I found, and this is how I'm distributing them. And so that is the whole process of the probate. In short, if a person has a will. Now, if you do not have a will, a lot of people ask me, hey, I have everything. I have a spouse, and everything I own is jointly owned. So, do I really even need a will? If I die, my husband get everything. If my husband dies, I get everything. That's just the norm, right? And so, do we really need a will? I don't have any children. Well, you do. You still need a will. If you own a home, your home is deeded to two names, and before you can sell that house, if one person dies, the name of the other person needs to be removed from the deed, and there's actually a process that goes with it to make sure that the house then belongs to just one person, and that person then has the capacity to sell that house. The same way, if you do have joint tenancy, as in you have things that are co-owned, one of the biggest risks that you encounter with that is, what if you die, right? What if I die a few weeks or months, years after my husband does, before I have even figured out what I want to do with my assets that came directly from my husband? Then at that point, how is that going to be distributed going forward? Because we were just joint tenants. The other big risk about joint tenants, and I'm also a lot of times asked, what if I put my children with me as a joint owner of a bank or a joint owner of a house? Well, the one important thing to remember is that when you put your house as a joint owner with your child, you are reducing your homestead, because your child, if your child is an adult, especially because you are the owner of the house and you can only file one homestead, and your child would probably have another house somewhere, right? And they would have the homestead of that house. So if you co-own a house, you cannot get complete homestead. Homestead is one of the biggest protection you can get in Texas, because homestead is not just an exemption for your taxes, but also it cannot be touched by a lawsuit. It cannot be touched by creditors. It cannot be touched by bankruptcy. It cannot be touched by a lot of different aspects of, it's just less risky to make sure that you have all your assets in a place where there's an exemption. So homestead is a huge exemption, and definitely is a big protection. Now, if you don't want to give your child a house